So now with this last chapter that we're going through, chapter 19, we're talking about estate planning. Excuse me. Yeah. Anyway, the learning objectives are to analyze the personal aspects of estate planning. You have to personalize all of these things. It's something that, we'll walk through that. Assess the legal aspects of estate planning, distinguish among various types and formats of wills, appraise various types of trusts and estates, evaluate the effects of federal and state taxes on estate planning. Again, this is at this point we're focusing, drilling down on the legal aspects of your planning and also the tax implications. Again, it always seems to come back around to these taxes, and that tax strategies are ever changing because the tax structure is ever changing. Whether we're talking about the federal, the state, or sometimes even the local level. Anyway, so first item we're looking at is analyzing the personal aspects. So personalizing this, if you will. So your estate, again, as it indicates here, it's everything that you own, all of your entire physical portfolio, your home, etc., all of your personal property, and as well as your financial portfolio. So your savings accounts and retirement accounts, etc. This is all part of your estate. This is your net worth in essence, if you want to distill it down to dollars and cents. So it's a definite plan, and it's how you're going to dispose. Well, actually, before that, of course, administer and then dispose of your property during and after your lifetime. During your lifetime. And we'll get into that with trust and so on and so forth, and how you want your assets to be divvied up once you're gone, right? So the essential part of retirement planning has two components. One is to build that estate through planning and so on and so forth, and all the different devices that we've talked about before, ranging from insurance to pensions, your physical assets in terms of your home and so on and so forth. And so that's the one side, and the other side is transferring all of those proceeds, if you will, how you want to transfer them upon your passing. So if you're married, you want to. So the idea is that you want to do what? You want your estate to be passed on in a smooth manner as possible onto your descendants, really. If you're married to your spouse, if your spouse is living, of course, if you're whomsoever you want to get the proceeds from your estate, from your physical financial portfolio, who's going to get this stuff, right? Typically, again, it goes to spouse and children. If you're unmarried, you can designate beneficiaries, and when I say beneficiaries, it's more than one. So more than one person is going to benefit from this. The reason you want more than one is that you want, if your beneficiary that you designate dies before you, then this would go to the state. We don't want that to happen. You want to make sure that you pass all of your assets on to someone that of your choosing, or some institution, if you will, of your choosing. Anyway, so a lot of stuff has changed, of course, and this is why, at the very least, at the end of this process, it's always I say this guardedly, but it's always worthwhile to run this past an attorney. All right, just keep this in mind, because again, as I say, and this is, as you know, as noted here, is that lifestyles are far different today than they were 20, 30, 40, 50 years ago, when things were relatively simple in terms of just passing something on to your spouse, for example. Something as straightforward as that. Things have changed quite a bit. So the opportunity cost of rationalizing, what we mean by that is that again, you don't want to be, this is the same thing as with your investing. You don't want to be going through this over and over and over and over in your head. You'd like to get this, hopefully it's one and done, meaning you set this up one time and it's done. Not to say that you don't want to revisit it, but if you can get away without revisiting it, that would be all for the better. So again, demands of daily living can keep people from thinking about death. So who wants to? But then again, when it's hanging over your head, not just the prospect of death, but what's going to happen to your assets upon your demise. If you can take care of this in as efficient, clean manner as possible, that would be awesome, right? So your beneficiary will have to meet with morticians, clergy, all these folks, and so on and so forth to transfer those assets from them to you to dispose of your remains, to put it bluntly, to plan out your funeral and so on and so forth. And it's it's a scary process. And if you haven't gone through it yourself, I'm sure that some people that have had to kind of walk through this process. So the quicker, cleaner you can make this, the better off you are. And this is why, again, you want to plan this eventuality, this certainty, when you're in good health, so you don't have to contend with this if your health is in decline, et cetera, right? So the legal aspects of estate planning, think about this in terms of items that we talked about before. Whenever we're doing anything financially, for example, life insurance, buying a home, uh, uh, there are others as well, but getting loans, period, from a bank, you have to have documentation after documentation. And in your estate planning, the legal side of it, you have to have loads and loads and loads of documents that are available. This is the place where, at the end of the day, if you have a safety deposit box, it would be good to keep copies there. You can also file a lot of these copies with your county, for example, with your registrar at your county. But anyways, we'll go on just to list necessary documents: birth and marriage certificates, legal name changes, social security documents, military service records, insurance policies, transfer records of joint bank accounts, safe deposit box records, registration of automobiles, title to stock and bond certificates. And a lot of these things are available online. But it's not to say that you don't want to have accurate and solid information. You want that. This is something that you would want printed out somewhere so that people are able to access this information upon your passing. Anyway, so will is a legal declaration of a person's mind to the disposition of said property after the death, after your death, or after the person's death, I should say. So it transfers the property according to your wishes. Again, you have the setup before, and what happens, how your estate, your financial and physical portfolio, if you will, again, is transferred on to those folks that you want it to be transferred to. So state laws determine the distribution of your estate if you die intestate without a will, which means this is when it has to go through what's called probate. And on the bottom, we've got down here is that probate is a long, costly process, and other people are in charge, not the folks that you want to have your possessions, your assets, your estate, but the state itself steps in and hangs on to it for a while, and there are costs associated with it that can get very, very expensive, especially with a large estate, meaning large complexity-wise and or large financially. What it's actually worth. So marriage and divorce affect your will, of course. This is again different changes in your life. You want to address these in your will when you change your will. And this is again where you want to go through and make sure that you go over these things with a lawyer. And again, it's a few $100s to do. You can do a lot of these things on your own, a lot of upfront, a lot of these will makers and so on and so forth. These are very good pieces of software where you can gather all the information, all those documents that you need, and kind of get things in order for an attorney, if you will. It'll lessen the cost of that attorney. So again, standard wills cost anywhere from $300 to $600. In my experience, it's been a bit higher than $600, not for me, but from what I've seen, it's more on the order of, we'll just say $500 to $1,000. And again, probate is that legal proceeding that if you don't have a will that is valid right up front. So different types of will that are out there. Simple will leaves everything to your spouse, straightforward. Traditional marital share will leave half of your adjusted gross estate to your spouse and half to your children or your heirs. So you can designate half and half type of an arrangement. An exemption will passes everything to your spouse except for an amount equal to the exemption, which passes into a trust. That trust then can provide a lifelong income for yourself, really is what we're saying, or for whomever. So a stated dollar amount will designates amount to be passed to spouse, and percentages are. And again, when we talk about this, is that the reason you want to break it up in percentages, because if you have a lot of financial assets, or for that matter, physical assets, you buy a home for $100,000, and 20 years later, in your passing, the home is now worth $500,000. You want to make sure that these are things are stipulated, not just for physical assets. It's a little easier, straightforward with physical asset, I suppose. It's kind of hard to split it up percentage-wise, but certainly it's an easier, smoother task in doing this percentage-wise in terms of financial assets. Okay, so holographic will is handwritten entirely. And this is the old-fashioned wills that you see where people said where I hereby leave all of my worldly goods and possessions to so on and so forth. That type of a will, where someone actually just writes it out by hand. A formalized will is prepared again with an attorney, and you have to be signed off with so it's a legal document with witnesses, etc. And point in this is something that's simple, because you go to an attorney's office and they'll make sure of this, of course, is that neither of the persons that are the people that are witnessing can be beneficiaries, okay? Receiving that property again under the will. Statutory will is a formal will on pre-printed form, and you can get, again, through Willmaker, I think it's called. It's through Quicken, I think, that there are wills that are available, and you can go through these, and these are dry runs and so on and so forth, and you have you can access actually statutory wills from your state, from your jurisdiction that you're in, of course, as well. And you set all these things up and go through and do the laundry list, etc. And just the same, even with a statutory will, again, because it's not necessarily meeting the state's requirements, for example, you want to make sure you run that past an attorney, if you will. Anyway, first step that you have so far is like the actual making this, putting this into action, is you have to have an executor. And this person is the one that follows your instructions. Find out if you have to find out, if the person is willing and so on and so able to do go through the various tasks. And it can be anyone over 18 years of age who has not been convicted of a felony. A person could be a family member, etc., friend. If you don't have if you don't name one, the court will do that. So this is in your best interest to find someone that, and not to say that it won't be impartial coming from the state, but it just smooths out the process. Executors fees are set by law. Again, it's very straightforward. The major responsibility of the executor is to go through, prepare an inventory of all assets, collect any money due, and pay off debts. And so they're the ones that are executing your will, your wishes, if you will, in your after you're gone. So they prepare and file all income and estate tax returns, liquidate and reinvest other assets if necessary to pay claims, distribute assets based on instructions in the will, make a financial accounting to beneficiaries and to the probate court. So they've got to finalize these things, wrap these things up. And you can see from this that the job can be quite extensive. It can get quite complicated. So selecting a guardian. So you have an executor who executes the will and passes, if per your bidding when you're alive, how those assets are distributed. A guardian is someone who is out there to take care of things after, again, you're passing, the folks upon whom that were dependent upon you. In particular, we're talking about children. So if you have children, you need a will to name their guardian and/or trustee. A guardian assumes responsibility for providing the children with personal care and managing the estate for them. A trustee will manage property for benefit of children. Be sure that this person is willing and able to raise children in the manner in which you want them. Matches your philosophical bent. Typically, they're family members, and a lot of these points are moot. They don't really matter if it's kind of a clean will where you're passing, everything goes on to your spouse. That makes, I hate to say it, but it makes the process much simpler. Just the same, it's important to go through all of these steps. Fortunately or unfortunately, at least once you do them, you don't necessarily have to change them, although that does happen, as we mentioned before. So altering, speaking of which, or rewriting your will. So review your will if there are changes, if you have significant changes, if you move, if you sold property, that was mentioned in the will specifically, size and composition of your estate have changed. If you have married, divorced, or remarried, if new potential heirs have died or been born, add a codicil. This is a codicil is an addendum, if you will. If only a few changes are needed, this is a document that explains, adds, deletes, etc., provisions that in your existing will. Consider a new will if making major changes. So, example, you have 5 nieces and nephews, and you wanted to divide your property up specifically between those 5 nieces and nephews. And what happens when you pass away is you have 10 nieces and nephews, but per your original will, all of those assets go to the original 5 nieces and nephews. You can set things up so that you can divide property up according to their parents, for example. Say that your brothers and or sisters or whomever, and it can be directed to them for them to dispose of their assets that got from you. Anyways, it can get very, very complicated. So the more you can do up front, the fewer problems that you encounter going forward. So prenuptial agreements are agreements before you get married, of course. And one or both spouses often waive a right to receive property under the other's will or under state law. And these, again, are after consultation with an attorney. You don't just say these things. This is a legal document, and these are things that, again, legal documents, and the aim is to to determine where your assets will be or how they will be distributed. Right? Living will and advanced directives. Advanced directives includes first off a living will, which again provides for your wishes in the event that you become physically or mentally disabled, and this happens, especially since people are living longer. There's an increasing chance to run into situations with dementia, with Alzheimer's disease, etc., where people are physically somewhat fit, we'll say, but their mental capacity is diminished. So we set these things up prior to. This is the whole concept. So it's not a substitute, of course, for a traditional will. Discussing your living will with those closest to you and your family doctor. Sign and date again before 2 witnesses. Give copies to those closest to you, close to you. A durable power of attorney, if you will, can be also set up for the healthcare side, to your wishes, and letters of last instruction after death wishes. How how your funeral is going, or what you want for your funeral if you want to have a funeral. Ethical will, new type of will that is a way to pass on your values and beliefs to your heirs. It's not a legally binding document, but nonetheless, it expresses your interest, right? And this is kind of a self, in some ways, it's a self-eulogy. And it's interesting. I've actually seen one of these, and um, it's as it says here, the writer and recipient say the results are an invaluable legacy. It's something that will, if nothing else, it'll last after until after your passing. Social media will, same idea with if you want to continue with your Facebook account, and if you don't want to, if you want everything deleted, you can set that up prior to. State in your will that your online executor should have a copy of your death certificate. You have to have, this is first thing, is that if you are the executor, if you're a spouse of someone who's passed away, you have to have several copies of death certificates, so that you can use that to enforce, if you will, for banking needs and so on and so forth. It can become quite complicated. Durable power of attorney. So this is getting into brass tacks, into specifics. It's also known as a healthcare proxy, legal document authorizing someone to act on your behalf in a variety of manners. If you are unable to make decisions regarding your healthcare, and specifically in this case, this authorizes someone to do that for you. So a durable power of attorney in terms of your healthcare is what we're talking about. Decisions, life and death decisions this is critical that you have someone that you can trust to do this, of course, for a variety of reasons, but mostly that you want to make sure that they make the decisions that you want, that you would prefer, if you will. Letter of last instruction after death wishes, and again, is not legally enforceable in most states, actually, so some. Provides heirs with certain, details regarding funeral arrangements, and provides directions how to get to your bank accounts, safe deposit box, etc. So it's kind of a cheat sheet for the folks that come after you that you want to pass on your assets to. So again, we're looking at the different types of trust in the states. So we want to appraise these. And so when we talk about a trust, first when we said a will, passing on your, that's very, very specific. You're passing on your assets upon your passing. So a trust is a legal arrangement through which a trustee holds your assets for your benefit or that of your beneficiary. So there's someone standing in your stead. That's a trust. So a trust is something that's set aside from you. It's a separate entity from yourself, but it's exercising, when it's exercising its power, it's acting in your interest. Hopefully, shouldn't say that, but yes, it's acting in your interest. So it takes care or manages your property. One. Used to assist used to protect assets from creditors, or manage property, again, for young children. Typically, this is very typical when you have trustees, when you have a trust set up for children, in the event of, again, of your passing. All assets are taken out of your name and put into that trust. So you have a car that's in your name, that's owned by you. You would move that ownership of the vehicle, if you will, from your name into the trust. So we're moving things kind of physically, but if not physically, formally into a trust. So This is created by the trustor or grantor. The person who is, or the persons who are setting this up are the ones that are specifically doing this, moving those assets from themselves into that trust. Those are the trustors. So trusts are either revocable, however you want to say it, or irrevocable or irrevocable. With a revocable trust, you retain the right to end the trust or change its terms during your lifetime. This may help to avoid, especially if it's somewhat complicated, helps to avoid lengthy probate process. Probate, again, is when the state steps in, and you want to avoid that as much as possible. That's why we have these set up, these wills, trusts, etc., to dispose of your estate, moving it from you onto the next, the person that you want to leave it with, right? Does not provide shelter from federal or state estate taxes, okay? So you're still liable for the taxes that are associated with your estate. The trust is responsible for paying those taxes, right? With an irrevocable trust, you cannot change the terms. It's irrevocable. Again, for tax purposes, the trust becomes a separate entity. If a large estate is used to reduce estate taxes, if you have a large estate, it's used to reduce the estate taxes and avoid probate. And that's something very specific, and the reason that it would be helpful in reducing estate taxes is that there's you may split this up among various people, your assets, and so on and so forth. And there are some reasons, and without going into it, this is something that is to consider. And above all else, you're avoiding with wills and with trust. You avoid probate. You want to keep this out of the hands of the bureaucracy or the bureaucrats. So the benefits of establishing a trust, we'll just walk through it. Reduce or provide payment of estate taxes. Avoid probate and transfer your assets immediately to your beneficiaries. So it goes immediately into effect upon your demise, whereas a will has to be exercised. You have to go through the executor process. A trust is out there, boom. It sets it up immediately. Frees you rather from managing your assets. Directing the executor to do it, so on and so forth, and all the costs that would be associated with that. Provides income for a surviving spouse or other beneficiaries. Ensures property serves desired purpose after your death. So you can be very specific about what you want done when you put this into your trust, where your estate is going to go, really. So different types of trust, credit shelter trust, also called a bypass trust, is what's called a residuary, not a residual, but a residuary trust, an AB trust, an exemption equivalent trust, or a family trust. So also there would be, those are sheltering for tax purposes and so on and so forth. A disclaimer trust, living or inter vivos trust, property management arrangement established while you're alive, how you want your assets not just disposed, how they're going to be taken care of kind of going forward. Testamentary trust established by your will. Life insurance trust, how your life insurance is going to be distributed, if you will, to beneficiaries, etc. So with the estate, you want, again, so far as the trust is concerned, very similar to the will, make an inventory of your estate, cash, bank accounts, CDs, money market funds, stocks, bonds, and mutual funds, and the list goes on and on. Life insurance, listing your home, any other real estate that you actually own, money owed to others, that your debts that are due that you want to be paid upon your passing, interest and trust. So if you are a beneficiary from someone else and you're receiving some income from a trust, you want to be able to direct that as well, where you want that to go. Any kind of physical assets, antiques, art, collectibles, cars, and all of your personal effects. Community property, is that you have either with your spouse or someone, siblings and so on and so forth, how you want that, um, uh, parted out, if you will. So it's all something you can direct into the trust. So the idea again is backing up as you want to move it from your possession into this trust, and the trust dictates where your assets are going to go. So joint ownership, this is typical with a home. Spouses often own property as joint tenants with rights of survivorship, and the property will automatically pass to your spouse. Estate tax is paid when surviving spouse dies. So these are this is a function, if you will, of being able to pass your assets on without being taxed if it goes directly to your spouse. So you're considered the same person in many ways. Anyway, so tenants in common, each individual is considered to own a proportionate share, and each can choose who gets the share after their passing. If you own a piece of property with siblings, with cousins, parents, whomever, you would be typically tenants in common. Tenancy by the entirety. When one spouse dies, the other gets the property automatically, which is very similar to the joint tenants and with rights of survivorship. But legally, it's something where it's specifically passed on to a specific individual, in this case, the spouse, right? So life insurance and employee benefits, life insurance proceeds are free, again, from probate and income tax, something to keep in mind. Assignment of ownership of your beneficiary can remove a life insurance policy from your estate. And unless payable to the estate itself, death benefits from qualified pensions, profit sharing, KEO plans are excluded from your estate. So interesting. Again, unless payable to the estate, death benefits from qualified pension, profit sharing, or KEO plans are excluded from your estate. So again, that's something important to keep note of. Lifetime gifts rather than trust. Gifts are a trust with strings attached. So upon the eventuality of your passing, you want this to your nephew to receive a monthly payment of $500. So these are things that you want that are explicitly stated in your trust, if you will. Controlling that property and so on and so forth. If you're the beneficiary of a trust established by someone else, you have the general rights to the principal during the life, or the power to appoint anyone on your death the amount that's included in your estate. So if you're to receive X amount of dollars throughout your, into perpetuity, if you will, so long as the money lasts, in the event of your passing, that portion can be passed on through your trust to your beneficiary. So it's a daisy chain type of a thing. So settling your estate, if you have a will drawn, you are testate, meaning you legally speaking, you're able to do, since you have a will in place, you have something set up to pass on your assets. So this is called you are dying. So you are testate. In the eyes of law, and an executor named in your will carry out your wishes in due time. If you do not have an executor name, this would be called dying intestate, intestate. So it passes to the court-appointed administrator, and can be a long, drawn-out process. So this is something to avoid at all cost, if you will. Some assets pass outside the will directly to your beneficiary. Typically, of such property as if you and your spouse have vehicles, it goes directly to your spouse. Again, it's most of this property. I shouldn't say most. It says some assets pass directly to your spouse, and most of them do. Anyways, in my experience. But again, this is something that you want to stipulate in your will to make sure that even that You want to, to dot all the I's and cross all the T's as much as possible. It's an insurance policy for your beneficiaries is really what a will is, or a trust for that matter. Federal and state estate taxes. So there are, of course, taxes, and the dollar amount, I guess I forget, it's um, federal, it's $500,000 or more, maybe even higher than that, but it's still, there are taxes at the federal and state level. So things are things to consider. Federal estate taxes, estate and trust, federal income tax returns, state inheritance taxes, think monopoly board, right? Anyway, so there are inheritance taxes, of course. Federal and state gift taxes, tax avoidance versus evasion. Remember, we're all about avoiding taxes, but evasion is what? Illegal. You're not going to be evading taxes. Charitable gifts and bequests, calculating tax itself, debts and liabilities, probate and administration costs, paying taxes owed. So these are all steps, part and parcel of this entire estate planning process, the steps that you have to go through, right? So anyway, that wraps it up. And this is, again, the legal end of it. So kind of in summary, we're looking at the disposition of all of your assets, of your estate, of your financial portfolio, of your physical portfolio, passing that on to whomsoever you want. Two different ways of doing it, basically. One is through a will, where you specifically identify who is going to be getting how much, and that has to be executed, and that is done by an executor, versus a trust. A trust is when you're alive. Again, a will is, of course, too, but a trust is when you're alive, you're transferring all of your assets, or the number of assets that you want to, transferring from your own possession into this trust. So when the trust itself can be revocable or irrevocable. It can be changed or not changed going forward. This is a very important part of the process, but the takeaway is that with an estate is that you're moving it from your own person to a separate entity. It's still taking care of you when you're alive. You can do what you want to for the most part, typically, but it's something that you're setting aside from yourself. So bottom line is that once you're done with all these things, tracking, gathering all of your assets, understanding what your assets are and what your liabilities are, how you want things to go in terms of having a durable power of attorney set up for one, your medical needs, two, your financial needs to take care of your estate as you're alive. In the event that you're not able to take care of yourself. All these things you run through, and if you have anything complicated at all, you want to make sure that you go through this process and go to a lawyer. Spend the $500 and take care of it that way. Anyway, thanks. This has been fun.